The exclusionary rule is a law that prohibits the use of illegally obtained evidence in a criminal trial. It involves constitutional violations such as improper search or seizure or unlawfully obtained confession. The history of the exclusionary rule is in the Weeks versus United States case in 1914. It established limits on the federal government's use of evidence. In Silverthorne Lumber Company versus United States in 1920, the federal use of secondary evidence was finally addressed and restricted. In the Wolf versus Colorado in 1949, security of one's privacy against arbitrary intrusion by the police, which is at the core of the 14th Amendment, is basic to a free society, which then did not extend to the state courts. In 1961, in the Mapp versus Ohio case, this Supreme Court case held that the rule had to be applied universally to all criminal proceedings. There are 4 exceptions to this rule. It's the good faith exception, which allows evidence obtained by law enforcement who relied on search warrant that they believe to be valid. Then it's the attenuation doctrine, which permits evidence and properly obtained to be used if the evidence and the illegal means obtained are very remote. Then it's the independent source doctrine, which permits evidence obtained later through an independent source through legal activities. The inevitable discovery rule permits illegally obtained evidence when apparent that the evidence would have been discovered legally anyway. An example of this rule would be the police illegally searching through a laptop, find files that link someone to a business scam. He then gets an informant to obtain the evidence and send it to him. The evidence is permitted because it was another independent source for evidence besides the illegal search that the officer committed.